Hi, everyone, and welcome to the next monthly Immigration Litigation Roundtable from Amica Center for Immigrant Rights Immigration Impact Lab. We're still getting used to the new name. For anyone who hasn't heard yet, we're now Amica Center, formerly CARE Coalition. And we appreciate all joining this training today to talk all about alternatives to detention, especially ankle monitors. And Evan Benz is leading the presentation. Thanks for being with us, Evan. He's a senior attorney in the lab. How are you doing today, Evan?
Doing great. Happy to be here.
Awesome. Okay, and given that, for this very niche topic, we do have a smaller group than usual, which we're kind of excited about because we want to hear from you all and have discussion. So please do come off mute and share your experiences as we talk about these issues, share your perspective, and I will go ahead and dig in. Sorry, always admitting people as I speak with these. All right, so just a quick background on the lab for those of you who aren't familiar with our work. So in the Amica Center, which is primarily focused on representation and legal services for immigrant adults and children subject to detention and deportation, the lab is our impact litigation shop. So we focus on trying to bring impact cases that have the potential to make better law for groups of individuals, and strategically appealing cases, launching advocacy efforts. We host these monthly roundtables as a way to connect with you all, increasingly around the country about the issues we work on, hear from what y'all are seeing on the ground, hear your ideas, brainstorm together, strategize together, and share resources that we can be helpful with. As always, we're open to hearing referrals as well. If you have any cases on the types of issues we're talking about or that you think we should take a look at, feel free to reach out anytime. The best way is to email lab@amicacenter.org. In terms of how we do impact litigation in the lab, we do arrange, most of it traditionally has been individual-based impact litigation, which looks like individual appeals to the Board of Immigration Appeals and the Circuit Court, as well as individual habeas petitions challenging detention, and now also ankle monitors, as we'll be talking about today, in federal district courts. So through our cases, some make it up and do create new precedent, and a lot of it is just pushing the courts really to kind of start hearing these new claims and, defending and arguing for immigrant rights. Okay, with that being said, we'll dig in to the presentation for today. So a little overview, background on this topic of alternatives to detention, which you'll hear us refer to as ATD, which includes things like ankle monitors, GPS monitoring, electronic monitoring, check-ins. These are forms of surveillance and control that cause physical, mental, social, and financial harm to our clients. ICE uses these so-called alternatives to detention as alternative forms of detention in their eyes, or incarceration. We have a different view on that I'll be talking about momentarily. And there are ways that we can fight back about the increasing use of ATD through advocacy and litigation. And Evan will be sharing some of the strategies that he's been leading for Amica Center in this presentation. So first, we're going to talk about a brief history and overview of ATD. Then we'll talk about the legal framework governing review of ATD conditions. And then finally, ways to push back on harmful ATD conditions. Okay, so the first kind of piece we want to start with is just a little bit of messaging, how we're thinking about ATD, how ICE is using ATD, and what the scope of ATD is today. So the numbers are pretty astonishing. There are now, as of June 2024, 5 times more people enrolled in ICE's ATD programs than folks who were held in ICE immigration detention. So this is a tool that ICE is increasingly using to expand its reach and surveillance and control over immigrants' bodies, over their physical liberty, and be able to watch them and surveil them, and control where people go. So it's something we've had our eyes on for a while at Formerly Care Coalition, now Amica Center. And when you hear the term alternatives to detention, it's kind of already saying the government's perspective that they do view it as an alternative, right? It's that it's not detention. And certainly all of us who have actually worked with individuals impacted by detention and by these control mechanisms, like, we all know most individuals would prefer an ankle monitor or other forms of monitoring rather than detention. So we're by no means saying that, it's like the same thing. But we do want to make the point in this presentation that we do not think that ankle monitors and other forms of ATD are actually viable alternatives to detention. We believe that they are still another form of detention that restricts liberty. It's just people are not physically held in a detention center, but their lives are still impacted in many ways, particularly through ankle monitors, which are some of the most harsh forms of ATD. So the type of impacts that we can see restricting people's body movements and liberty are listed here: the GPS ankle monitors, the SmartLink phone app, which is increasing in use, geographically restricting movement, curfews, and check-ins. Evan, do you want to say a word at all about kind of like what you've seen in all the research you've been doing on which of these are being used the most and like increasingly being used?
Sure. Yes, we've definitely seen, and we'll get into this a little bit in more detail in some of the next slides, but there has been under the Biden administration over the past couple of years, there's been a rapid expansion of ATD and the number of people that are enrolled in ATD. And with that, we've seen a rapidly increased use of GPS monitoring, especially ankle monitors, and overwhelmingly the SmartLink phone app, which is something that can be installed either on a government phone or on an individual's personal phone, and which has GPS tracking technology. So those are some of the trends that we've seen over the past couple of years.
Thanks, Evan. Yeah, so just to sum up, question the term, right? I think it's easy for us to just kind of like blindly assume it is an alternative because it's in the name, and that's certainly ICE's position. But we just want to encourage folks to question that a bit and see these as forms of the restriction of liberty that habeas petitions can be appropriate for, which we have done successfully in a few cases now. Some of the harms that we have seen with clients and that Evan has been gathering in the academic research that is out there establishing the harms for people around the country include physical harms, so aggravating serious pre-existing health conditions like diabetes and leukemia, physical discomfort, wearing on people's ankles on a daily basis, electric shocks for some folks. We have had clients who have had trouble sleeping at night because of it, who have underlying challenges, including like schizophrenia that really exacerbates their mental health challenges. There's also mental harm. So people have reported having suicidal thoughts due to ankle monitors, aggravating pre-existing trauma and PTSD, as well as mental health disabilities. Socially, it really can lead to a lot of isolation, all of like the shame that is involved with having that on your body, not wanting people to see it, ostracization, and then there's also fear of harming people's communities by having law enforcement more involved in checking in on them and tracking them, and not wanting to bring harm to their family members and loved ones. Financially, this has been something that we have found interesting to like play up to the courts. That seems to be not appealing. I don't know what the word is. Like having some interest by judges is the loss of employment that they can cause, right? Some folks' employment, they can't wear an ankle monitor like that, so they cannot get the job, or they lose their job by having this ankle monitor on them, and so they're not able to maintain it. or for example, if they need to travel to certain areas for work and their alter ATD agreement says they can't, go to certain areas or leave their local area. So with that background, I'm going to turn over to Evan to continue on to an overview.
Yeah, and to thank you, Dina, for highlighting those aspects of ATD. And I want to get into a little bit of the history and the current state of ATD sort of nationwide. ATD for ICE began in 2004 with the launch of the Intensive Supervision Appearance Program, which ISAP is the acronym. There are now multiple ATD programs, including the Family Expedited Removal Management Program, the FIRM program, the YACMP, which is the Young Adult Case Management Program, which, as an aside, I haven't talked to anyone who has had a client in the YACMP, but would really be interested to hear from anyone who has come across a client who's been enrolled in that program. And then there's also the Case Management Pilot Program, which we'll talk about a little bit later. But ISAP remains, by and large, the largest ATD program. And generally, when people are talking about ICE ATD, they're referring to folks that are enrolled in ISAP. ISAP has grown steadily over the years, but grew exponentially following 2020. At the end of fiscal year 2020, there were around 85,000 people enrolled in ISAP. And as of earlier this year, there were 184,318 folks enrolled. So an over twofold expansion under the Biden administration. And this actually leaves out that I think the ATD enrollment reached a high of over 350,000 towards the end of December 2022. And I think that there's a number of, well, to finish with the numbers, more than 150,000 people are being surveilled by ICE currently via the SmartLink phone application, and over 20,000 people are subjected to ankle monitoring under ISAP. Some of the other programs like FIRM also requires ankle monitors for members of asylum-seeking families, but they're not included in this number as far as I know. And the average time spent under ATD surveillance has also increased over the past several years or past several decades as well. Recently, the nationwide average of time spent under ATD surveillance was more than 18 months. And some field offices, because it's an average, some field offices will have, shorter lengths of time of average enrollment. But some offices like Newark, Detroit, and St. Paul, I think, have averages of over 2 years of ATD enrollment. And I think that in terms of the numbers that we've seen and the expansion that we've seen under the Biden administration, I think that there are probably, a number of factors that have led to this expansion. One is that, in the practical world of politics, and in an administration that came in 2021 with a more, let's say, humane posture towards asylum seekers and other immigrants, that alternatives to detention maybe seemed like a better option than, family detention or return to family detention or something like that. I think that also coming off of the pandemic and also the uprisings around racial justice in 2020, there was really a move towards decarceration, towards getting people out of cages. And we've seen law enforcement agencies and law enforcement agencies across the country, both in the immigration context and in the criminal legal system, move not towards actual freedom in terms of decarcerating folks, but into something that some people call e-carceration, where there's electronic monitoring on folks that may have previously been incarcerated or jailed, but now they are freed, but not free exactly. They're still under the control and surveillance of the state. So a wider context to also keep in mind as we're talking about these issues. Let's go to the next slide, please.
Thanks, Evan. I'll just mention to a lot of the companies that my understanding, Evan would know better, that were invested in immigration detention have been also have investments in the use of ATD. So it's kind of like they've just shifted their where their profit comes from. Is that right? Or
Yes,
sources of
definitely. That's
income.
right. That's definitely something to highlight. That the ISAP program is operated by BEI Incorporated, which is a subsidiary of Geo Group, which to many of you was a notorious name. They're the private prison company that runs private prisons for the federal government, as well as immigration detention centers, and they also are very invested in the development of these ATD programs and the technology, especially the ankle monitors and the SmartLink app that goes along with them. That's a big part of how they make their money. Um, Diving into the legal framework governing review of ATD conditions. So this is, as Adina mentioned, somewhat of a niche area, and I find that some folks are not aware that there is a framework for non-citizens to get review of their ATD conditions. If those conditions are harming them in significant ways, they do have the right to request at least amelioration from an IJ or from ICE, and it depends a little bit on their specific posture, the posture of their immigration case. So ACFR 236.1 and 1236.1 lay out the procedures for people moving through standard INA 240 removal proceedings. So these are folks that are not subject to reinstatement. They're not in withholding only proceedings or anything like that. They've received an NTA and they're seeking to defend themselves against deportation. Under the regulation, they have 7 days after they've been released from custody. That's the language in the regulation, to seek review with an IJ. And there's a BIA case from 2009 interpreting release from custody to mean release from detention. And so 7 days after you've gotten out of detention, if you can somehow find a lawyer, get all of your papers together, document the harms that maybe this ankle monitor or SmartLink app is causing you, then theoretically you have the right to seek review of those conditions with an IJ. After those 7 days, the regulation says that you must seek review from ICE. And we'll talk a little bit more about de-escalation requests later on in the presentation, and I'd love to hear from folks about their experiences with presenting de-escalation requests to ICE. But what I've heard so far from folks all across the country is that generally ICE ignores these requests, that the most common response is just silence, or maybe a perfunctory acknowledgement. We've received your request and we'll process it in the order it was received, something like that. And that's problematic for a number of reasons, but not least of which because under the regulations, you also technically have a right to appeal to the BIA if you disagree with ICE's decision on your amelioration request. However, if there is no decision from ICE, if they just simply ignore your request, then there is no decision to appeal from, right? This is in violation of ICE's own ISAP handbook, which says that they're supposed to be reviewing ATD conditions on an ongoing basis, sort of affirmatively reviewing the compliance of ATD participants and making de-escalation decisions on that basis. So if you've been compliant for 6 months, no issues, and you're on an ankle monitor, it would stand to reason that you would probably be eligible for de-escalation, but it doesn't seem that ICE is performing those regular reviews. Their handbook also says that within 2 days of receiving a de-escalation request, they're supposed to respond in writing, as to review the file and respond in writing with their decision in response to that request. But again, in practice, that's not exactly what we've seen in the field. And we can go on to the next slide, please. So that's for folks who are in, like I said, quote unquote, standard INA 240 removal proceedings. There is a slight asterisk to that where folks who have been subjected to expedited removal and are later paroled out of detention, that regulation might not actually apply to them, but happy to talk further with folks if they're interested in that. Um, but that's a main bucket is folks in standard removal proceedings, and then another main category of people on ATD are people with administratively final removal orders. And under the regulations, there is no ATD review procedure outlined for those people. Um, and this includes people that are subject to a FARO, a final administrative removal order, where they never maybe even got to see an IJ, or a reinstated removal order, um, in which case, if you've got a reinstated removal order and you're maybe seeking withholding only proceedings, as you're going through those proceedings, you don't have a regulatory right to request review your ATD conditions with ICE or with the IJ. This would also include people that have one withholding of removal or CAT protections, and people who have stays of removal or orders of supervision. So as an example, last year we represented in a habeas petition a client who, after a horrific experience in immigration detention during COVID, was released on an ankle monitor, spent several years on that ankle monitor as he was going through withholding only proceedings. And then he won his case at the IJ level. The BIA or DHS appealed, the BIA remanded, and the IJ granted protection again. And several months after his case had wrapped up, he had submitted de-escalation requests via his counsel, but he was still on an ankle monitor and he could not get a response from ICE. This person was not going anywhere. They were not going to be deported. There was no reason for ICE really to still be tracking him. And it took filing a habeas petition to finally catch ICE's attention and get the ankle monitor off, which they happily did. We can move to the next slide, please. So now, yes, talking about some of the ways that we can push back on these harmful ATD conditions. And I think that it is worth emphasizing that ankle monitors are in some ways the most obviously harmful form of ICE surveillance that's included in the ATD programs. They're obviously, highly stigmatized within society. They're highly visible. They mark you in the way that, a kind of scarlet letter would back in the day. And at the same time, with the growth of the SmartLink app, which also has GPS tracking capabilities, we need to be careful to not only be focusing on ankle monitors, but also on the SmartLink app, and basically trying to push back on ICE's use of this surveillance technology, without any warrant requirement, without really any individualized, without any review by a neutral arbiter like an IJ, as to the necessity of this surveillance. It's really been used in a very overbroad and kind of unrestricted way by ICE, and we have no idea what they're doing with the data. We have seen them use GPS data in at least one workplace raid, a very large one. I believe it was in Alabama several years ago. So there's great concern about this use of warrantless surveillance of hundreds of thousands of people in the United States.
And then quick question for you, just for folks to understand why it is so problematic to have the GPS monitoring on the phone. Because, it might be easy to think, well, it's not touching your body. There's no restriction of physical liberty. It's just another app on the phone. So if you could give the example, I know we were talking about the other day, the woman who crossed state lines, and kind of bring it home why it's very scary that they're doing this to people.
Yes, definitely. Thanks for bringing that up. So yes, there is this maybe first impression that the SmartLink app is, less invasive or less restrictive than like an ankle monitor. But in folks with people that I've talked to, including an organizer in Missouri recently, the mere fact of knowing or wondering what ICE is doing, how much they're tracking you, what they're doing with the information that they're gathering, it takes a psychological toll, and it does feed into this social isolation as well, where If people know that that's happening, they might not want to associate you with you. If you might make the choice to not put your family or loved ones at risk by essentially exposing their location, right, to ICE if you can at all avoid it. I've heard of stories of people who, stop going to church or stop participating in other social events because of this fear of ICE showing up because they're tracking you. And yes, one story is that ICE and BIA claim that the SmartLink app only monitors your GPS location when you're doing a check-in. So how it works is people are required at certain intervals to actually like take a selfie, a photo, and submit it via the SmartLink app. And they need to be usually in their home or in a certain location when they're doing that. But there have been anecdotes of folks getting calls from ICE or from ISAP officers where they're moving and it maybe appears that they're not in that they've crossed a geographical limit that ICE has imposed on them. And they've gotten calls from people from ICE or ISAP asking them what they're doing. So there was this organizer I was talking with in Missouri. She had uh, a woman who was on SmartLink who lived in Missouri. My Midwest geography is not great, but I guess St. Louis borders Missouri and Illinois, and she happened to have crossed into Illinois for some purpose, and ICE actually called her and was like, "Whoa, what are you doing?" And she was like, "What are you doing? I thought you weren't tracking me all the time." So again, with the lack of transparency from ICE and BI around this technology, we don't know what we don't know in terms of how they're using this data or how they could use this data, but I think there's a lot of reasons for concern and a lot of need for oversight and further transparency. Um, and that's part of what we at Amica Center and the Immigration Impact Lab have been looking at different ways to push back on these conditions through advocacy and through litigation primarily. In terms of advocacy, I think it is worth considering continuing to advocate for increased funding of the case management pilot project. This is a pilot project, as you can tell by the name, that involves more support for folks who are going through removal proceedings rather than just pure surveillance and restrictions on them. So this pilot program is actually run through DHS, but not through ICE. It's actually run through FEMA. The Office of Civil Rights and Civil Liberties is involved in the direction of the program as well, and they contract with legal service providers and other nonprofit organizations to provide services or provide referrals to folks that are going through removal proceedings. And although it might not be the ideal version of what we at Amica Center are advocating for, which is community-based case management programs, it seems like a step in the right direction. And unfortunately, its funding was cut earlier this year by Congress, so there's need to continue advocating for that program. We also at Amica have recently filed a petition for rulemaking with DHS and DOJ, and we were joined by 28 other great organizations across the country, including some of the orgs from where people on this call, I believe, are representatives. And we are calling on the agencies to amend the regulations to basically eliminate the 7-day deadline for folks in INA 240 proceedings to allow IJs to review ATD conditions at any point during the removal process, and then also to amend the regulations to allow for folks with final orders of removal to also have IJ review of their ATD conditions. And that's part of an advocacy push that we just recently filed. In July, we filed the petition and are going to continue pursuing that advocacy with the agencies. There's also room for congressional advocacy and oversight, and I know that there are tons of great organizations across the country that are heavily involved with that form of advocacy as well.
Thanks, Evan. I'll just read out one question we got. on the legal framework on a prior slide. Let me see if I can go back. Yes, so the question is the mention of appeal to the BIA, was that referring to an appeal of the IJ review within 7 days or something else?
Yeah, that's a good question. So you have the right to seek IJ review within those 7 days, and if you disagreed with the IJ's decision, you could appeal to the BIA from that decision as well. What I was referencing is that after the 7 days, if you request de-escalation with ICE and you disagree with their decision, you also have the right to appeal to the BIA from that decision. Assuming you get a decision, which that's the hard part.
Okay, thank you. So there's two opportunities to go to the BIA, but the first one requires you go to the IJ, right? And the second one requires that that ICE gives a response, which we don't have much control over.
That's
Hence
right.
the need
I,
for federal litigation.
Yes. I also would be fascinated to hear if anyone has successfully appealed to the BIA from an ICE denial of a de-escalation request. I did submit a FOIA to EOIR, but they didn't quite understand it, and I didn't get very good data back. But my assumption is that almost no one ever has been able to appeal to the BIA from an ICE denial of a de-escalation request, but would be curious to hear if anyone has experience on that.
Evan, have you ever heard of anyone getting a denial from ICE or instead of a non-response? And has anyone else heard of that on the call?
Yeah, this is Matt Bowles. At least for the Atlanta ER field office and Charlotte, they certainly are not shy about denying. In addition to
Okay.
non-response, but I've received explicit denials before.
In any chance you all have had a chance to try a BIA appeal in that scenario? I know resources are tight. Just curious. I see Jessica also said she's gotten denials in New York.
Personally, I've never appealed. I mean, I know that you can't procedurally, but I haven't in that type of situation.
Well, thanks for letting us know. And then I see Selma saying in the chat that she's had tried several times to contact ICE Baltimore for a client, never responded. She used a form letter. Very frustrating. Yeah, that's usually what we see. I'm sorry you had to experience that. Someone else asked about sample de-escalation requests. So I was gonna see if we have any internally, but if anyone on this call has a good sample they want to share, please feel free to reach out to Evan or me. We can kind of pull those together for folks. Iman is asking what would be the mechanism for appealing to the BA? Would it be if we do receive a denial versus email, for example? I think so, right? Like it has to just be what, written?
Yes, I think that if you have a written decision, you would file the E26 to the BIA. Although I'm wondering if that form actually can be used for like an ICE decision or if there's a different decision. Um,
Well, you can appeal a bond denial, but that's not ICE. Yeah.
right.
Yeah, it's a good question. That might be why it hasn't been done. Who knows? Anyone
Yeah,
who
that's a
wants
great
to
question. I
try
may need to
that,
look into that a
yeah.
little more.
And Jessica's asking if it's under 236.1A6. The
D2 is the ICE decision, and then I think it's D3 is your right to appeal.
cool.
Yeah, but so let's keep going and talk a little bit about de-escalation requests because it sounds like folks do have experience with this and would love to hear more about those experiences. Anything that stands out to you that has worked in the past. I have some suggestions, but it does seem like it's a bit of a crapshoot in dealing with ICE. So I think that the best practice is to try to get the attention of the local ICE field office director. So if you're able to um, email them directly, or perhaps better yet, personally accompany a client to a check-in and present the de-escalation request that way. I've heard that having that personal contact, makes it harder for the ICE officers to ignore the request. I think it's important to include evidence of compliance, emphasizing really any positive equities, right, that your client has. If there's a prospect for immigration status or relief, community ties, lack of recent criminal history, those are all great things to include. Letters of support. You can almost think of it as like a bond packet in some ways. And this is, I think of it as somewhat parallel to like a bond proceeding. It's a bond proceeding for non-detained folks. And thank you. Jennifer is also noting that the ATD fact says that attorneys can accompany clients to these check-ins. So that's good to have in your back pocket if you ever get any pushback about your presence there as the attorney. I do know that like some folks will email de-escalation requests to like a general inquiries email address that the local ICE office might have. I think that to the extent that you can direct it to the field office director, you're more likely to get a response, whether that's a positive response or not. I do think that it's worth trying to get it in front of that person's eyes. I'm not seeing the slides anymore.
Yeah, sorry, something happened, but I will get it back up.
Yep.
There we go. Can you see it now?
Yes, thank you.
Okay.
And one sort of strategy call that you would talk about with your client is possibly proposing other ATD conditions that would be acceptable to your client. So if it's the ankle monitor or the SmartLink app that's really really causing the most harm, interfering with their job, it's going off all the time. They have to step out from their work to take this selfie or whatever the case may be. Proposing some sort of alternative in terms of like phone check-ins or in-person check-ins might make it more persuasive to ICE to agree to take the GPS device out of the ATD conditions and impose different ATD conditions. But yeah, we can maybe pause there, and I would love to hear if anyone else has recommendations for like best practices, things that have worked for you in the past in de-escalation requests, getting those granted. And I think Matt Bowles maybe in particular wanted to speak to that.
Yeah, I was just gonna add, sorry that my camera's off, I can turn it back on. I work for the Southern Poverty Law Center, and I'm one of for ALA for Georgia, Alabama. I'm on an ICE liaison, so this comes up pretty much every quarterly call. At least for Atlanta, what they always recommend is that they want it emailed at least a week before someone has a report date if it is in person. So at least what I generally do, we'll send it 10 days, and then once I get like an automatic response, like that's like the receipt. And then I make sure that my client has a copy both of the email, but also, and I just use my like as a PDF. It's generally what I've done, and I do a pretty comprehensive timeline. So yeah, so if anyone, especially in the Atlanta area, needs support, I mean, I've done it a little bit for Chicago. I feel like Chicago's a little bit easier, at least then they always kind of defer to the Milwaukee sub office, and they're pretty responsive. But yeah, I mean, I agree with almost as if it's like a bond packet in front of like an IJ, especially at least in the denials that I get, sometimes ICE will say why, or maybe they'll say, okay, in 3 months we'll reconsider. So I'll just put on my calendar and say, hey, I'm following up because you said to follow up now. It's generally what I've done. I've also sent things to ICE case review. So I don't know. And sometimes they're responsive, sometimes they're not. Sometimes they argue that the person's not detained. I argue kind of what you said earlier, like, well, no, you have the right, you have the authority to review this. So I've never done anything with the BIA, but I would consider doing an ICE case review. And then I usually get a response, even if they just affirm the decision. They usually will give me some kind of information or a response and usually more information.
Yes, thank you for mentioning the ICE case review. It's an email address, right, that you can escalate a case to, I guess, supervisory review. I know that we tried that for at least one client um, who was in 240 proceedings. And if I remember correctly, I think that they basically said that they wouldn't review it until there was like a final decision in the case, in the removal case. So yeah, that was of little help to us. But that is an option that, you know, might be worth pursuing. And I'll see if I can, I'm not sure if I can dig up that case review email.
That I can do.
Oh, that'd be great, Matt.
They,
Thanks.
they definitely require like a specific denial, although so sometimes I'll reach out to Atlanta and say I need you to like specifically write no or like denied or whatever. But yeah, I can find that in the chat or post
That's
in.
right. Okay. Yeah. That's right. It wasn't that they were waiting for an IJ decision. It was that the entry level like DO hadn't made a decision. There was no decision formally on the de-escalation request. We tried to escalate it via the case review, and they said, "Well, we haven't made a decision yet, so there's nothing to review here." Um, so again, one of the difficulties of escalating, trying to appeal a decision that doesn't exist sometimes. And I see that Jennifer dropped the link to the case review process. Thank you. Great. So I think we can go on to the next slide and talk about litigation as an option. We, over the past year or so, have worked with a couple clients to bring habeas petitions to try to get relief from ankle monitors in particular. And they've been successful so far. One was in Eastern District of Virginia, one was in the District of Maryland. And by successful, I mean that ICE, within a few weeks of filing, agreed to take off the ankle monitor and so effectively mooted out the case. I'll say at the top that I'm really interested in working with folks, co-counseling or mentoring on litigation like this across the country. So anyone that's interested, has a client that you think would be a good plaintiff for a habeas petition like this, please do reach out to me. I'll go ahead and drop my email in the chat. You can email me directly. But I put a lot of details on the slides because you can refer back to them later. I'm not going to go through all those details today, but do want to dig into some of the kinds of claims that we've presented that, again, we haven't had the chance to get to a merits decision from a federal district court judge, but we think that these are some of the viable claims that could be brought in a habeas petition. And I'll say just one side note, I don't think it's in the slide, but in terms of like jurisdiction, that for folks that have a final removal order, habeas jurisdiction is like pretty well established, even if you're not detained. For folks that don't have a final removal order, it's a little grayer, but we think that, you know, the sum of all of these different liberty restrictions should be sufficient for habeas jurisdiction. So that's one thing to keep in mind if you're presenting or preparing a petition like this. But some of the strongest claims, I think, are APA ACARDI claims, ACARDI being the doctrine that the agency, ICE, has to follow its own mandatory policies, and that it's arbitrary and capricious for them to not do so. And so we've argued essentially that there are a number of policies that ICE should be following as they set ATD conditions for people, review ATD conditions for people, and respond to de-escalation requests. And, you know, 9 times out of 10, they're not following any of those policies, it seems like. So I do have a list of them here. There are sort of general ATD policies about case management. There are specific policies for folks who are pregnant or diagnosed with a severe medical condition. There's the ISAP handbook, which again lays out how often they're supposed to be doing case reviews and how quickly they're supposed to respond to de-escalation requests. And there's a directive from 2022 to work with, this is for folks with diagnosed severe mental health conditions. And there's some language in there that I think is helpful in terms of like working with counsel to ensure that ATD conditions are not unduly burdensome or something like that, that it's basically not going to aggravate this person's underlying mental health conditions. So I'm happy to share all of these via email. Again, if you want to shoot me an email, I can send them over. They were all, I see Jennifer's question in the chat about if the handbook is publicly available. I've learned through all of these policies via two FOIA cases that Stanford Immigrant Rights and Berkeley Immigration Clinic litigated a few years back now. And so I'm happy to send it over email if it's easier, but I dug through some of those FOIA responses and found these policies, some of which, you can see date back to the Obama administration. So I'm not actually sure if they've been superseded or rescinded. But I haven't heard otherwise. So until ICE says so, I'm going to presume that these are all still in effect. And of course, some of them are more recent, like the handbook itself or the ICE directive. And so I think we can go to the next slide. So in addition to the APA ACARDI claims, we can also look at due process claims. The procedural due process claim, trying to boil it down, is basically that the process that's provided for under the regulations, both for pre-order folks and for post-order folks, is insufficient to prevent erroneous deprivations of liberty, which is an important, right that all non-citizens have or should have. That varies a bit on your jurisdiction in terms of how far the court is willing to go in terms of recognizing liberty interests of, especially folks with final removal orders. There's some bad language in different circuits about those folks having reduced liberty interest in the due process context. But essentially arguing, that the process, that we need more process here in order to guarantee due process is being respected, that the rights of these folks are being respected, and that having your former jailer, ICE, review the conditions that they've set for your release is insufficient. You need a neutral arbiter, you need an IJ, and of course, we know that IJs aren't always exactly neutral, but better than having, an ICE officer who may or may not, have legal training or a law degree, probably doesn't, to review your case. So without getting too much into the weeds, that's sort of like the essence of the procedural due process argument. And then I think it's worth including a substantive due process argument, basically pointing out that because immigration proceedings are civil in nature, it is a substantive due process violation for ICE to impose ATD conditions that are primarily punitive. And that one's going to be very, very tough to convince a judge to agree with. But I think that at bottom we are seeing, at least in some cases, and probably pretty generally, that ICE is using this technology in a way, especially the ankle monitors, but perhaps also the SmartLink app, to punish people for seeking asylum, to punish people for criminal records where they've already served their time and rehabilitated and have tried to reintegrate into society, and that it's worth understanding that a lot of this, despite what ICE may say, does have to do with punishing non-citizens, essentially for being non-citizens. That's kind of my personal belief. And there is an ABA Commission on Immigration report that's linked to at the end of this presentation that has the title "Electronic Monitoring Punitive, Not Prudent." So even the ABA, sees this use of electronic surveillance technology as being essentially punitive, which is not allowed constitutionally, ICE in the immigration context. I think we can go to the next slide. Right, so additional resources. We do have a link to, and I think Adina will send these out after the presentation along with the slides and the recording. We do have a policy brief talking a bit about community-based case management programs as a true alternative to detention, as something that would move us closer to, welcoming folks with dignity, to supporting non-citizens as they move through their immigration process. It's closer to, sort of our vision of and the vision of many other organizations working on this issue of what a real alternative to detention could look like. We'll include a copy of the petition for rulemaking as well, in case you're interested. And then there's some other reports and at least one webinar in there that's been helpful for my personal development and thinking on these issues. And I feel like I'm very much still learning from other folks and directly impacted people in terms of hearing their stories and really understanding what these programs look like on a lived kind of day-to-day experience. And then I think the next slide is for questions. Would love to hear any questions you all have, and again, or brainstorming before questions. Yeah. But yeah, would love to open up the floor to anyone that would like to contribute.
Just one thing I'll throw out there, and then we'll open it up. Thank you both to Marianne and Amelia from the lab who pointed out the form for the appeal of the ICE denial to the BIA is likely to be EOR 29, since that's the form for ICE. So I'll put that link in the chat as well.
Thank you.
Both.
Thank you. It's all about the forms, right, in immigration.
Yeah. Yeah. And like Evan said, we'd love to hear people's experiences and questions. Feel free to come off mute.
Hi, this is Jessica from Bronx Defenders. We have a weird fact pattern that's come up twice recently that I just wanted to flag for the group that we were considering challenging and honestly just decided to leave it alone because of this client specific facts. But this was just a regular 236A bond hearing. The IJ set bond, client posted bond, and then ICE on their own set additional conditions, sort of ATDs. It's pretty minor. It's not digital surveillance. Just at this point, it seems to just be check-ins. But we hadn't seen this before. Usually they just leave the bonds undisturbed, and ATDs were not discussed at the bond hearing. So just wanted to see if others had seen that before, and whether you thought that there was a mechanism for challenging those conditions if in the future we decided to do that, whether we'd go back to the IJ. We were thinking through a lot of things, and we ultimately decided to just we felt that we were fortunate to get bond granted, and decided to leave it alone as if it just remains kind of sporadic check-ins and nothing else.
Thank you for raising that. Yeah. And that's something I've actually only just recently started delving into a little bit more, is the division of authority under 236A, where the statute says the Attorney General is authorized to detain, grant bond, or grant bond with conditions or conditional parole. And it's clear that that authority is shared with DHS and with ICE in the way that they can grant parole, set their own bonds and everything. And I'm not sure if other folks have looked into that or have knowledge of how exactly that authority is delineated, or if it's totally overlapping. So yeah, I'm afraid I don't have, I'm not sure what I would do in that exact situation. Except that if the ATD conditions were really egregious, I suppose that within that 7-day period, you could go back to the IJ and ask for them to be taken off. The BIA has recognized that within that 7-day period, the IJ does have authority to ameliorate conditions that ICE themselves have added or applied to the client. So, but again, that's a case-by-case judgment call, because there's, I guess, risks involved with that as well, depending on if you feel lucky to get bond in the first place, then totally understand leaving it alone for the time being.
I can add that happened at least for us when the Padilla injunction was in effect for a matter of MS. Like a client would get a bond from an IJ, and even if DHS waived the right to appeal, and then after the Diablo were paid the bond, they would have like a report date, and they got some notice because of the pending litigation. What I ended up doing, I never appealed, but I would just have the client go, and it was only like in-person check-in. It wasn't like a monitor or the SmartLink app. And I just wrote a letter and would have a copy of the bond order showing that DHS OPLA here waived the right. And then usually then, after they attended one time, our clients wouldn't have to report again. So I mean, it's kind of informal. It's not litigation heavy, and it usually got the work done. And I can send that if anyone's interested.
That's great. Thank you for sharing that. And that does sound somewhat specific to that point in time where that injunction was in place. Is that right?
Yeah, that's right.
Okay. I see in the chat that Iman is adding that they've had bond hearings where IJs strongly encourage, quote unquote, strongly encourage, but don't order ICE to put the client on ATD even if they granted, which DHS often complied with. Haven't tried appealing those types of decisions. So yeah, in that case, again, you could try a de-escalation request with ICE as a sort of, if you're beyond the 7-day window. And then if you get a negative decision, try to appeal it, or doing the case review process that we talked about earlier.
I'll mention too, for the habeas petitions we have done on ankle monitors, we have not gone through the exercise of trying to appeal to the BIA first. We didn't think it was necessary, so just throwing that out there as well.
That's true. Thank you for flagging that. In both of the cases that we worked on last year, ICE had not responded to the de-escalation requests, so it didn't seem like we needed to or could go to the BIA to exhaust like administrative remedies. I also don't know specifically if exhausting those remedies would be necessary, strictly necessary for like a habeas petition. But I guess that also depends somewhat on your jurisdiction.
Great. Well, since we're just at time, I will mention our next roundtable is going to be September 5th in the Crimim area. We'll be digging into more post-Chevron Loper-Bright discussions with the categorical approach, specifically around CMTs. And we've got some good sample briefing coming for you all for different circuits for CMTs after Loper-Bright. So stay tuned. If there are any topics you all want to hear about, please do reach out. We want to hear from you all. These are the ones we've planned for the rest of the year, but subject to demand and what you all need. Thank you all so much for joining. Is there anything else you want to add, Evan?
No, just really, thank you everyone for coming, and especially those who have contributed and shared their experiences. I really appreciate it.
Yeah, thank you everyone, and I'll send out the replay shortly. Take care.